Now, our third and last statement. If you run your leasehold like a business, then an eviction should not wreck your profit. Ernie, I know you have lots to say on this, but not everyone you deal with is familiar with the eviction process until it's really thrust upon them. I know from your talk last week, you had lots of experience educating clients. Could you walk us through the process and what does an eviction look like?
Sure. I'll give you the quick run through of eviction because it is a necessary tool that landlords will need to know something about. And if you carry it out expeditiously, you'll find that you can recover property quickly. So the first thing you have to do is you have to determine the default. If there is a default, you have to give notice to the tenant. Typically, this notice is a notice to vacate. And typically, it's due to non-payment of rent. That's what most evictions are about, non-payment of rent. If you've waited 3 or 4 or 5 months before you've sent this notice, you're losing money. And so that's not an effective way to stay profitable. If within the first week of a non-payment, you have delivered this notice, number one, you're likelier to collect it. And number two, if you begin the process that soon, you're likelier to reduce your losses. Remember, you're holding probably 1 month of rent on deposit. So it's possible to recover your property for a minimal loss and apply that security deposit to the unpaid rent for that month, but not if you don't begin the process quickly.
Yeah, so you really need to look at it as money on the table, basically, because when time goes by, you're losing just more money.
Absolutely, absolutely. And then the snowball effect kicks in. If they didn't pay the first month and the problem that caused non-payment persists into the second month, you can anticipate that the second month also will go unpaid. This way, if you've begun the eviction process during the first month, even if the second month is not paid, but if you can recover possession within that second month, then again, you're limiting your losses. And again, you may not ultimately cut your profit.
Wow. And I think of the 2 instances we had in which we leased a house to a friend, and then they had trouble. And then we had grace, and there was more trouble. And it just mounted. In one of those cases, they paid up. In the other case, we just ended up losing a good deal of money there. So things can drag out, though, if they appeal the process. Can you talk to us about that and kind of what perils might be there?
Sure. So one thing that landlords don't know is they'll take their case to the justice court and they'll win a judgment. And they feel that because they have the right paperwork, they won a strong judgment, that it ends there, that there's no basis for an appeal. Like, I followed the law to the letter. Unfortunately, in the state of Texas, every single judgment that comes out of the eviction court is subject to an appeal. It doesn't matter how perfectly the landlord filed. It doesn't matter how terribly the tenant was in default. Every judgment that comes out of the justice court is appealable by matter of right.
Well, so how do we prepare for that?
Well, if you know the rules, you can use the rules in your favor. So if, for example, a tenant loses for non-payment of rent and you receive a judgment, generally speaking, there's one of 2 paths that they'll take. Either A, they'll pay a cash bond to secure the judgment on appeal, or B, they'll fill out an affidavit that will allow them to proceed on the basis of payments into the court registry on a regular basis. That first payment is rent for that current month. And then subsequent monthly payments go paid into the court registry. But too many times landlords come to me deep into the appeal process, and the tenant hasn't made any of these payments. And they don't know that the moment they miss that first payment, you as a landlord are entitled to immediate possession. A writ for immediate possession means that the judge signs an order and the constables come out and forcibly remove the tenant in a much faster process than you can waiting for your trial to get to appeal. But if you don't know the rules, you don't know how to use them in your favor, it could mean you collect a check at the end of your appeal process, or you collect possession before the matter ever gets to the appellate judge.
Well, it sounds like a ninja tip there. I mean, that's big. And so time is really of the essence on the landlord to act quickly.
And knowledge. A landlord who doesn't know their rights can't enforce them. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing.
Can you give me an overall timetable for these so someone
Sure.
going in can kind of understand? Because some things are just really absolute, like 21 days or et cetera.
True. So pre-pandemic, the eviction process in the Justice Court was limited to 21 days by statute. The Texas Rules of Civil Procedure said your eviction trial will happen within 21 days of filing. Well, those rules are out the window momentarily. I'm sure that eventually we will be reestablished. But on average in Harris County, we're looking at about a 30-day turnaround. Now, that's not universal. There are some courts that are still taking multiple months to set these trials. They are so far behind. And with COVID protocols, it is much more complicated to run all of these evictions. And so we say about 30 days. Some courts are quicker. Some courts are lagging a little bit behind. But about 30 days for a Justice Court eviction from filing to trial. As for an appeal, you're looking at about a 1 to 2 month delay. So from the moment of an appeal, you can expect at least 1 month before you're in front of that appellate judge, which is why it's necessary to know the limitations here, to know what obligations does your tenant have. Has the tenant met those obligations? And if not, what can you do? And so we're going to get into the weeds if we get too deep into the procedure. But within that 1 to 2 months time, you could actually, again, recover possession before the matter ever reaches that judge. With regard to a writ of possession, which I spoke of earlier, which is that order from a judge to physically remove, this is the constables that come out and physically remove people and property. That process in practice takes about 2 to 3 weeks. We call it immediate possession, but nothing that runs through county government is immediate,
Right.
Except for maybe the due date of your taxes, right? And so the constables will post a notice. They'll literally tape it on the door, and it says you got 24 hours to go. And I'll tell you that 99% of tenants who see that, they bolt. But you have that 1% that's going to stick it out, and they're going to make you wait the full 2 to 3 weeks, right? And they will be forcibly removed, and you will recover possession of your property, but you're going to have to wait out that time. So you might win a judgment, they might not appeal, or they default on appeal, and then you still got to wait 2 to 3 weeks, even after the court has signed that writ of possession. It's a process, but in the end, you will recover property.
If they won't get out, I know that it's popular to think, okay, well, we'll give you $500 if you move out. What are the legal ramifications and impact on the lease if you want to do something like that?
I've seen that happen. I've seen that happen successfully, and I've seen that go really, really wrong.
Wow.
So you'll want to position yourself in a way to make sure you're giving money. They call it cash for keys, right? And so if you're not actually getting keys, you're not giving over the cash, right? And so you can have something in writing established with your tenant that says, on day X, if you have cleared the unit and given keys to me, upon your exit, I will give you Y number of dollars, right? And so that approach works best because there's a motivation for the tenant to vacate in exchange for money, and you're motivated to pay the money because getting possession is much more valuable than the money you're otherwise spending. Where I've seen it go wrong is where landlords continue to trust their tenant, and the landlord pays the money first as the motivation for the tenant to move, and then the tenant fails to move. And unfortunately, when that happens, you're in a tough spot because you stuck your neck out and they had no skin in the game themselves. And so now you're beginning the eviction process when if you had started it from the moment of default, you might not have had to pay any money. I want to say that the appeal process in an eviction is much more formal than in the Justice Court. In the Justice Court, it's easy peasy. You take good paperwork to the Justice Court, and generally speaking, you're going to win the day. Most evictions are very successful in the Justice Court level, right? I'd say about 75% of them are wins with no appeal. It's that 25% that get into the appellate court or the courts of appeal downtown here in Houston, Harris County that can pose a problem.
Well, 25% seems to me like a high number for something like eviction. So this is routinely processed by probably a good number of attorneys in town, yeah.
You would think that with numbers that high, we'd get a lot more of these cases, but generally speaking, the appeal is filed for one of two reasons. Number one, just to buy additional time, or number two, because there's a valid defense to post. But most of the time, on appeal, the tenants will have left. They know they have 1 to 2 additional months. They use that time to pack up and leave. And what ends up happening is that landlords who don't follow that judgment lose the original judgment. They don't know this, but that original judgment, by virtue of the appeal, is gone. So guess who doesn't have an eviction on their record? Your terrible tenant. Now, you're happy because you got possession back, but the record is incomplete. And so I always urge landlords to go and get that judgment, to make it stick, because if you don't, that tenant's never going to learn a good lesson. They've learned how to game the system.
Wow, that's why you were so emphatic in our meeting, trying to get these guys to really just follow the lease and do that up front.
Absolutely.
So, yeah, now what you said really makes a lot of sense now.